Charge number 1, condition of obey all laws under subcategory of weapons. Your PO reported.
On 5/3/2023, you were photographed standing next to an unidentified male who was holding an AR-15 or similar assault rifle with an inserted drum magazine, while you posed for the photo displaying the BLOODS gang sign. The firearm was within arm's reach of your person and therefore was an area under your control.
Charge number 2 under travel. Your PO reported.
On 5/2/23 until or after 5/4/23, you were in Los Angeles, California without prior written permission from your parole officer.
Charge number 4 under gang affiliation, gangs membership. Your PO reported.
On or prior to 11/17/22 through your return to custody on 1/18/24, you have continuously claimed and or demonstrated membership in the BLOODS gang, which is a designated security risk group of the Connecticut Department of Correction.
Charge number 4 under gangs, contact with members. Your PO reported.
On 4/2/23, you accepted a phone call from an incarcerated BLOODS member and you stated that you were going out west for Bishop Hood Day. On 5/2/23, you traveled to Los Angeles, California for a summit amongst ranking members of the Five Deuce Pueblo Bishop Blood Set, which is based out of the Pueblo del Rio housing projects in that city, which is held annually on May 2nd and is attended by several other members of the BLOODS gang, a designated security risk group of the Connecticut Department of Correction.
Charge number 5 under search. Your PO reported.
On 1/18/24, you refused to provide the passcode to a cell phone that was found in your possession when your assigned parole officer asked you to provide it for the purpose of conducting a search. The same phone was used by you immediately before it was confiscated, indicating that you had access to the phone.
All right, so those are your charges, and there is evidence that the state submitted. Would you mind going through that, PO Hayes?
Oh, he's muted.
Oh, you're muted, PO Hayes.
Exhibit A, Connecticut conditions of parole. Exhibit B, remand to actual custody order. Exhibit C, notice of parole violation and parolee rights. Exhibit D, parole violation report. Exhibit E, inmate photo of Salvador Kevin, inmate number 366186, taken 7/15/21. Exhibit F is a Instagram page controlled by the offender with a URL ended in Pueblo_Don. The front page and stories received 5/18/23. Exhibit G, email correspondence regarding communication with LUSMAT, inmate 371043, and face sheet of LUSMAT. Exhibit H, DOC incident report ending in 007. Exhibit I, contraband physical evidence tag ending in 01. Exhibit J, photos and notes from iPhone received 11/16/23. I'm sorry. That was Exhibit J. Exhibit K, photos and texts from cell phone received 1/12/24. Exhibit L, contraband physical evidence tag ending in 02 and photograph. Exhibit M, DOC incident report ending in 003. Exhibit N, photographs taken 1/18/24. Exhibit O, Instagram page ending in URL Pueblo_Don, front page and post received 1/18/24. Exhibit P, Facebook profile ending in URL 979. Exhibit Q, offender misconduct report signed 6/1/23, and Exhibit R is a U.S. Attorney's press release from 8/25/2010.
All right, thank you. All right, so at this time, the state will have an opportunity to make a short statement, call any witnesses, or speak to any evidence. PO Hayes, is there anything you would like to add regarding the charges at this time?
Sure. So adding to the both the gang membership and gang contact with members charges, I would like to point out that since Salvador was returned to custody, he was designated an SRG member of the BLOODS. He was given an SRG score of a 4, which is the highest classification an inmate can receive, and he was placed in phase 1, which is the highest phase that an SRG member can be placed into. But also, I'm sorry.
Go ahead. No, that wasn't me. I'm not sure who that
Okay.
was.
All right. Going down to charge 5, search. I'd like to point out that he did not give up his passcode when he was remanded to his cell phone. He was offered a subsequent opportunity to provide that passcode when I served him his parole violation notice. I provided him with a sticky note to write it down on. He wrote it down. After bringing that sticky note back to his cell phone, it was unable to unlock the phone. So that charge is remaining, and I think that charge is important because, as we know, Sabayer, whether he's revoked, reinstated, he will likely be reparoled at some point since his special parole goes until 2030. So I would definitely like that charge to stick because he refused to search once, and if he comes back out on supervision, I'd just like to establish that he refused to search of his possessions at one point, and for the future of supervision, we're going to keep that charge on at this time.
Okay. Okay. Anything else?
That's it for now.
Okay. All right. So is there anything you would like to say or counsel on your behalf regarding the charges?
Yes, thank you.
Yep.
In regards to charge 1, weapons under Rebuttal laws, we would submit there's insufficient evidence to support this charge. The only evidence submitted by the state is a photograph of an unknown person holding what appears to be a firearm. However, there's no evidence submitted to substantiate that the alleged firearm is actually real as opposed to a toy. In addition, if we made an assumption that it was real, there's no evidence submitted to determine the operability of the alleged firearm, which is a requirement under Connecticut general statutes. Lastly, there's no evidence to support the allegation that the alleged photo was taken on 5/3/23. In regards to charge 2, travel, we would submit there's insufficient evidence to support this charge. The state submits photographs as evidence that my client was in Los Angeles, California. However, the photographs themselves are not conclusive evidence that my client was in fact in California. It is well established with posts to Instagram and Facebook that one can post a photograph of which the date of creation does not necessarily correspond with the date the photo is posted. The location data that is seen on Instagram and Facebook is based on data entered by the person posting the image. For example, I could take a picture that I took in my office here in Waterbury 3 years ago, post it today to Instagram. I can alter the location and indicate that I'm in New York, and this does not mean that the photo is recent, nor does it mean that I'm in New York. In addition, there is an allegation located in the narrative to the PBR that my client's phone connected to a Wi-Fi network associated with JetBlue. However, I do not see any documentation submitted in support of this statement. Further, even if I took that statement as true, it is not definitive evidence that my client was the individual using that phone on that date, and there's no evidence to suggest that he was on a flight that was going to California. There's no airline flight roster that shows my client's name on it with confirmation that he checked in for a flight. The parole officer submits evidence of a log that presumes to be messages from my client's phone, but there's no indication how those messages were extracted, who extracted them, the program used to do the extraction. I have no way to cross-examine that document without any foundation as to how it was in fact created. For all I know, anybody could have typed that document, including the parole officer. Exhibit G is an email from Daniel Papusha to PO8, and it's a summary of a call allegedly made from Alan Lusmat to my client on April 2nd of 2023. There's no evidence submitted to support the allegation that this call took place. There's no cell right analysis of my client's phone that shows he received a call from DOC and that the call came from Mr. Lusmat. Further, there's no recording of that call provided to defense counsel, and I'm not sure why. If Daniel Papusha was able to listen to that call and conclude that it was placed to my client and that my client was on the other end of that call, then I should have been provided a copy of that recording as well. My client cannot control who calls him. The charge alleges that my client said he was heading out west. It doesn't say California, and it doesn't say he was going to the Bishop Hood Day. The state mischaracterizes the email summary from Papusha and makes assumption as to what its meaning is. If you actually read the email, that is not what it says. Lastly, my client was given permission previously to travel to California from a prior parole officer. And I'm certain he took photographs during that trip, as noted in the narrative. In regards to charge 3, gang membership. Pointing out the language of the rule, I will not associate or affiliate with any street gang, criminal organization, or with any individuals thereof. The elements, he expressly identifies as a member, or repeatedly, continuously displays or possesses any signs, symbols, colors, or items that Parole knows or reasonably should know to be associated with criminal organization or street gang, and that the Parole knew or reasonably should have known that the organization or group was a criminal organization or street gang. We would submit there's insufficient evidence to support this charge. The charge itself does not allege any manner in which my client is demonstrating gang membership. I certainly can make assumptions based on the evidence that was submitted. First, there is no evidence to suggest that my client has expressly identified himself as a member of any gang. He has never introduced himself in that manner to anyone, nor is there any evidence submitted that he has. He does not possess a membership card. Secondly, there is insufficient evidence to support that my client repeatedly and continuously displays or possesses any signs, symbols, colors, or items that Parole knows or reasonably should have known are associated with a criminal organization or street gang. Going through the evidence. First, I think it's important to note that none of the images that were sent to me as evidence are colored photographs. They're all in black and white. Exhibit F are 20 Instagram images. 3 of those are photo images posted as a post, quote unquote post. 17 of those images are posted to the story. The total posts on my client's on the alleged Instagram account is 59 posts. And those do not include the 17 images posted to the story. Thus, 3 out of the images in Exhibit F are among the 59 posted images. That's 5.1% of the images that my client allegedly posted to his Instagram account are submitted here as evidence. That means that 95% are not submitted here as evidence. And I would suggest that's because those images do not support the allegations in this parole violation report. We therefore submit that this evidence does not establish that my client was repeatedly and continuously displaying or possessing any signs, symbols, or colors associated with a street gang. Exhibit K are 5 photographs, the foundation of which has not been established. They appear to be images posted from social media. However, as I said, there's no foundation indicating that. There is data information located to the top of the photos, but again, there is nothing submitted to show how that information was obtained. Exhibit N are 3 images, which are black and white, of which there is no foundation for who took the pictures and when. The images depict what looks like bandanas. The first image, the bandana contains the Haitian flag. My client is Haitian. Exhibit O, 5 images. If you look at the first image, it tells you that 97 images were posted to the account. However, 5 images are submitted here as evidence. That's 5 out of 97 images, which is the equivalent of 5.1%. So again, there are 95% of the images associated with this account not submitted here as evidence. Exhibit P purports to be 20 images from a Facebook account. This is an account that contains 452 images, yet only 20 of those images are submitted here as evidence. This is the equivalent of 4.4%. Again, there are approximately 96% of the images on this Facebook account that are not submitted here as evidence. If my client is allegedly wearing red, which you cannot determine based on the images submitted, and showing signs of gang membership, then he's doing so in less than 5% of images allegedly associated with these accounts. Exhibit J is a document that purports to be taken from my client's phone and from the notes section. There's no foundation linking this information to his phone. There's no extraction data shown that would indicate that the information came from a particular phone number and thus the phone associated with my client. Based on the information submitted, which does not include the number of the phone associated with the contents in the document, this information cannot be verified. Further, there's not only no information provided to connect my client's phone with this information, but there's also no information provided as to when the document was created. I would also point out that my client is alleged to be associated with the BLOODS, though the content of Exhibit J isn't explained. What exactly is this document purporting to prove? There is certainly no documentation submitted to show that information in Exhibit J is part of the structure or bylaws of an alleged associated street gang. In regards to charge 4, gangs contact with members. The language of the rule is I will not associate or affiliate with any street gang, criminal organization, or with any individual member thereof. Elements is that the parolee had prolonged or repeated contact with members of a criminal organization or street gang. The individual contacted was a member of a criminal organization or street gang. At the time the contact was made, the parolee knew or reasonably should have known that the individual contacted was a member of a criminal organization or street gang. The contact was in furtherance of the operation of the criminal organization or street gang, and the parolee did not have permission to violate this rule. We would submit there's insufficient evidence to support this charge. First, my client did not contact anyone. An individual by the name of Alan Lusmat, who is purportedly a gang member, is alleged to have contacted my client. It's important to note that this charge alleges one phone call made to my client. That would hardly qualify for repeated and continuous contact. Second, in regards to that alleged conversation, the state submits Exhibit G, email from Daniel Papusha to POH, which is the summary of a call allegedly made from Mr. Lusmat to my client on April 2nd of 2023. There's no other evidence submitted to support the allegation that this call even took place, or though there is supposedly an audio recording of this phone call, it was not provided. There's no cell-rate analysis of my client's phone that shows he received a call from the Department of Corrections and that the call came from Mr. Lusmat. If Daniel Papusha was able to listen to that call and conclude that it was placed to my client and that my client was on the other end of that call, whether by voice recognition, some sort of way to identify the voice on the other end of that call, then I should have been provided with a copy of that recording as well. My client has no control over who places a phone call to a phone that he sometimes uses. The rule provides that my client was making contact with known gang members. Here, the phone call in question was allegedly made from an inmate at DOC to my client. The charge alleges that my client said he was heading out west. It doesn't say California, and it doesn't say he was going to the Bush of Hood Day. The state very clearly mischaracterizes that summary and makes assumption as to what its meaning was. Based on Papusha's summary, it was not expressly stated by the recipient of the phone call. And again, we don't know who answered the phone call because we don't have a copy of the recording. And even if we did, we are not voice experts. The recipient was intending to travel to California to attend Bishop Hood Day. Thus, none of the evidence submitted supports them that my client was contacting known gang members repeatedly or for prolonged periods of time in furtherance of the operation of a gang. At best, there is evidence that someone answered a phone call made to a phone that my client has used, and that the person who made the phone call is an individual that is known or has been identified as a gang member. There's no proof that my client should have known that this individual or his status or affiliation as a gang member. Lastly, there's no evidence submitted to support the allegation that my client was in California and associating with known gang members. There are no names or individuals with whom my client is alleged to have associated with in California, and no information regarding their affiliation with any gangs. In regards to charge 5, search, we would submit there's insufficient evidence to support this charge. The parole officer was in possession of my client's phone, the phone that he uses. He is not the actual owner of that phone, however. My client provided the passcode to the parole officer on January 23rd of 24, and I know that the parole officer is maintaining that he was unable to access that phone. However, on January 24th, the day after my client provided the passcode, I will indicate that a router was ordered and delivered to the owner of the phone, which is my client's girlfriend's mother's house, in my client's name, and that router was allegedly ordered from the phone. So it would be difficult to order a router from a phone if the phone wasn't accessed. So we would submit that the parole officer did in fact have access to that phone, and that my client is not in violation of that charge. Nothing more as to the charges. Okay, but I could be heard on
I'll wait until the second part.
Okay.
It's
Yep.
serious enough, right?
Yes.
All right, wait till the second. All right, so, any PO hate, any response?
He's muted.
Oh,
Yeah,
he's muted.
that's
Okay,
a,
there you go.
that's a lot to unpack. Hold on. Okay. So starting with charge one weapons, attorney stated that there was no date attached to the photo. The photo that was extracted from Savier's phone, there is a date. Picture photo was taken on 5/3/23 shortly after midnight. That date was provided to me from forensics security division. They use very sophisticated software to find these dates and analyze the data from this phone.
So I
so
wasn't
there
saying
is a
the date
date.
wasn't, I just want to
Yeah.
respond that I wasn't saying the date
I-
wasn't included. I just wanted to be clear. I was indicating that there was no information provided as to how the extraction was performed. That's all.
Ma'am, you said there was no date when you were talking about that charge, and I waited a very long time to answer that. So just can you please give me a chance to go through what I want to put through here?
Absolutely.
All right, thank you. All right, so there absolutely was a date attached to the photo that was extracted from his phone. There was no date on the original Instagram picture. That's why we had to confiscate the phone, send it up to forensics, have the data analyzed. That picture was taken on 5/3/23. As far as travel goes, there are dates attached to the photos of the travel, namely the picture with the firearm. That picture was taken in California, and it was taken on 5/3/23. As far as the JetBlue connection to the Wi-Fi, that was extracted from his phone via forensics up at security division. As far as gangs membership goes, you mentioned the phone call from him. Daniel Papusha is the captain of the security division intel team. I accepted his summary of that phone call as for what it is. It was Alan Lesmat calling Kevin Savier, and Savier talking about going out west, meeting in California for the Bishop Hood Day. All right, excuse me one second. Going on to the gang membership section. I'm sorry, excuse me. I know it was mentioned that the photos were all in black and white. The evidence I provided was all in color. I'm not sure why you got copies of the evidence that was all in black and white. Everything I submitted was in color. You can see the red bandanas in every single picture that I
So
submitted.
I just want to clarify on that. So on the computer, if you look at the evidence, it's all in color, correct? So if you print it out on a black and white printer, it's going to print out black and white. So I just want to clarify.
Yeah, the evidence when I look on my computer is still in black and white.
It is?
Yes.
Okay. It's not on mine. Okay. Go ahead.
Okay. All right. In Savier's social media pages, he very prominently refers to himself as Lottie. The evidence that was extracted from his phone and the Notes app that has a pretty much a big history of the Pueblo Bishop Blood gang refers to Lottie as a YG with the GGA sect of that gang. It refers to OG Scully, who is actually a alias of Luzmat as OG. So also submitted in evidence was the Exhibit R, U.S. Attorney's press release, where the Pueblo Bishop Bloods have actually been charged under the RICO law. That same evidence shows that OGs give orders to YGs. YGs perform acts such as, excuse me one second, I wrote it down. Providing guns and money to furtherance of the gang by means of either crime or other, I'm sorry. One second.
Yep.
Okay, so I'm just going to read this, and just keep in mind, this was taken directly from Savier's phone. A YG is to breed soldiers with good traits, negative or positive.
Yeah. Hold on
Supervise
one second.
OBG.
Hold on one second.
Yes.
Yo, hey, hold on. Yeah, so that's the document from the note. It's in the
Okay, that's
email.
all that.
Yeah,
Okay.
yeah. Go ahead.
Okay.
But I read it. I mean, I don't.
Yeah.
I don't
All right. It says actively interact with the bigger homies, communicate as much as possible, provide guns through collection or kitty money through war, organize, protect,
Yeah,
and discipline through war.
we both read that document, so we don't need to have it read again. So is there anything else you would like to say regarding defense's arguments?
Give me 1 second.
Yep.
Okay. All right. Just that everything that all the evidence that's presented from the phone that was found, that was all given to me from Security Division. One more thing that the defense stated was that we only used part of his social media pages. It was Security Division who went through his social media, and they pulled what they thought was most important to make the case that we made today from his social media account. So the pictures that were submitted are the ones that are relevant to what he's being charged with. I'm sure there were other pictures up on his social media that were not relevant to what he's being charged with today, and that would be the reason why those were not included. As far as the phone goes that was confiscated when he was remanded, that phone was the one that he texted me from to let me know he was here in the lobby at the police department to check in. That was his only phone on his person when we patted him down. For any claims that that phone doesn't belong to him, it's the phone that he used. It's the phone that had the number that he called me with since I have been his parole officer. I don't know where this, claims that a router was purchased on the phone that was in my, possession when I was unable to get into it. I have no idea what that is supposed to mean or what you're insinuating with that. That's all I have to say.
Okay, thank you. All right, so I actually have a question here. I gotta find where I saw it. So in the documents of the text messages, where can you just tell me a little bit about where that was from? The document of the text, the graph with all the text messages. Did that come from Security Division as well, or where's that from?
Yes, that came from Security Division. The text messages was part of the second data dump I got from the forensics office up at Security Division. They sent me stuff in November, and then they sent me a final report in January.
So I do see like all these pictures and stuff. There's a bunch of pictures that you submitted as evidence, but I'm wondering, is there anything from Security Division regarding the text messages and his location?
Well, the
Not
text
a
messages,
statement, not a text message saying I'm in LA. I mean a location saying this was the location where he was when he sent this text message.
no, that was not sent to me.
Okay.
So, I mean, if he, I don't know if the argument here is that he made a coordinated effort to text somebody stating he's in California and also post pictures stating he's in California and also take pictures saying they were in California. But that's, if we're looking at a probable cause as whether he violated his parole or not, I mean, this is a lot of events coordinating at the same date.
Okay.
That I don't see how it can be ignored.
Okay. Thank you. All right. Anything else?
The only thing I would, one last thing.
Yep.
DOP did mention that he was given a report and that there was some type of system that was used to do this extraction to provide him with this information. However, it shouldn't be neglected that it's important for us to have that information as well. Just because you were given a report that maybe, I don't know if it was Celebrite, I don't know what program was used. Defense counsel has a right to know so that I also can take that report, provide it to my expert, and have them take a look at it and see interpret that extraction for me. I'm just given information here that has no connection, no foundation whatsoever as to how it was obtained. And I'm just supposed to take it as face value. And that's very difficult for defense perspective because I'm denying my client the right to confront this evidence against him by not having the information as to how it was provided so that I can have somebody take a look at it. My office has the ability to have an expert take a look at the evidence, except for I don't have it. And I've had similar cases where the actual Cellbrite analysis was provided to me, and I was able to take a look at it, and I was able to have an expert take a look at it and tell me that the data was being interpreted in a specific way, because I am not an expert who can interpret that data. So I was able to do that because it was provided to me. In this particular situation, it isn't provided to me. So I have a hard time with that. And that's all I'll say in regards to the evidence.
Okay. All right, so charge number 1, condition of obey all laws under subcategory of weapons. So regarding weapons and the elements to establish a violation under this charge, a weapon has to show that it can be from which a shot is or could have been fired by the force of an explosion. There's no way for me to tell that that weapon could be fired to establish that it was actually a real weapon. So I am making a no finding on that charge. Charge number 2 of travel. So, I mean, the only evidence I have is pictures of screenshots from different social media pages. Don't speak. I'm just kind of thinking in my head right now. So that's what I have is pictures of screenshots. There was a conversation where allegedly Lost Matt called him, and there was a talk about going out west. But again, defense argued that we don't have, what does out west mean? Does it mean Western Connecticut? Does it mean, what does that mean? It sounds like it was kind of assumed by whoever was reading that, that it meant going out to Los Angeles. Due to insufficient evidence, I am making a no finding on the travel charge. Charge number 4 of gang affiliation under gangs membership. So for both of these charges, gangs membership and gangs contact with members has to be prolonged and repeated contact to establish probable cause. So okay, so charge number 3 of gang affiliation, gangs membership. I am making a finding of probable cause based on evidence testimony from PO Haight, specifically regarding the fact that Mr. Saver is currently an SRG4 in the SRG gang program identified as a blood. So I am making a finding on that charge. Charge 4, contact with members. Again, prolonged, repeated contact. He did not contact the person in the facility. Lost Matt contacted him allegedly. So I am making a no finding due to insufficient evidence regarding the contact with members. Charge number 5, search. I am making a finding of probable cause based on evidence provided by the state in the PBR and also the testimony taken by P.O. Haight today as well. It sounds like there was 2 opportunities given. I'm not sure about the argument regarding the router that was ordered from the phone. I do find, at least regarding probable cause, I do find that there is enough regarding probable cause for the search. All right, and I know you wanted to be heard. I'm serious enough?
Yes.
Okay.
I will just indicate that my client was in the community for approximately 2.5 years. That this would be the first violation of parole, that he was working full time, sponsored by his girlfriend. He does have a 2-month-old baby that he was supporting financially. He was working full time at City Line Distributors in West Haven. He does have that employment to return to. So we would submit that this is not so serious as to warrant further incarceration, and that he should be allowed to remain in the community, to continue working, and to provide financial and emotional support to his girlfriend as well as his 2-month-old baby.
All right, thank you. P.O. Haight, is there anything you would like to say regarding serious enough?
Yes, I absolutely think it is serious enough for him to be continue his incarceration till a revocation hearing can be held. I will go further to say that I think that it would be important for him to finish the SRG program before there is a revocation hearing. I know that's typically done in revocation proceedings when there's a pending criminal charge. And I know the Board of Parole will not hear a new parole case if an offender is designated SRG. This being my first revocation proceeding dealing with SRG membership, you know, I'm sure that's something the board can do. I do think that they should just continue incarceration until he's able to finish the SRG program. From what I've uncovered, and I've done a lot of research on this specific blood set that Xavier is a part of. It's a very violent set of the gang, the Bloods gang. You know, I mean, I know it wasn't established that he did travel to Los Angeles on 5/2/23, but that is when they hold their Pueblo Hood Day every year. And they've done it every year since 1972, so they've been around for a long time. As I submitted in the evidence, they have been charged under RICO, and under the alias of Lottie, you know, he is in that GGA lineup along with Luzmat, who is the alias is OJ Scully. They have a heavy presence here in Connecticut, a very sophisticated command structure, and they are a severe threat to the Connecticut Department of Correction. Evidence taken from Xavier's phone. They have codes for different DOC facilities. They have codes that they use for other SRG groups. They have ways of communicating with each other. What we're able to find through this investigation from Xavier's phone has actually made our facility safer, because we have some of the terms that they use, that they've used concealed communication from Department of Corrections Security Division. Examples of that would be just the terms they use to deal with their rank structure. They use certain clothing designers. They use terms, different religions to refer to different sects of SRG memberships. Just one example I have is the Catholics were the Latin Kings. And I think that's as far as I want to go with that one. But
Okay.
Yeah.
Okay, thank you. All right. Mr. Xavier was out in the community for about 2.5 years, it looks like. No prior violations noted. I do have the one misconduct for the unauthorized travel to PA, and he was given a sanction of a GPS at that point. PO is recommending a 12-month sanction and no contact with BusMap. And I did make findings on gang's membership and search. All right. All right, so I did make findings on those 2 charges, and I do find that it's serious enough to warrant revocation, and that you should be detained while you wait for your revocation hearing. So at the revocation hearing, myself or another hearing examiner will determine if you violated the conditions of your parole and what, if any, sanctions should be imposed at that time. Okay, and I just want to, speaking to you, P.O. Haight, regarding what you said about the Mr. Saver not having a revocation hearing until after he completes the program. So yes, he is, like you mentioned, he is an SRG member. However, that doesn't apply for revocation proceedings. So he would have a revocation hearing, just like as this is a technical violation. So he would have his revocation hearing probably within the next month or two, regardless of the fact that he's an SRG score. Okay.
Understood.
All right. So I'm going to get a tentative date for a revocation hearing. So March 19th, tentative revocation hearing. This could change, but I'm aiming for the March 19th date, okay? All right, so this concludes the preliminary hearing for Kevin Saver, number 366186. All right. All right, you're all set. Good luck to you, sir. Thank you, P.O. Haight.
Okay, thank you.
Yep.
Thank you.
Thank you.
Kevin, I'll be in touch with you.
Okay, appreciate you.
All
Thank
right,
you.
thank you.
Thank you.
Okay, so let's unpack that. Man, it's a lot to unpack. Okay. These parole revocation hearings, and this is only a preliminary revocation hearing. So he's going to have his official revocation hearing on the date they provided, and I'll be sure to bring it to you when that happens. But they're only allowed to even bring up 2 of all of the findings as a matter of evidence to that official parole revocation hearing. So the idea that he was flashing gang signs, that's someone with a gun, can't mention that. The idea that he flew to California to attend this event, can't mention that. The idea that he was having the only thing that they can mention is that he is affiliated with a gang. And what's interesting is that they're able to do that. I felt she was only comfortable with what the board member was only comfortable doing that because he was assigned that level in prison. So she's not going to say that the prison was wrong, right? And then also for not giving his phone password. So that was, something that she claimed. But that's the only 2 things that they're going to bring to his actual parole revocation hearing, which doesn't seem too bad, right? So I'd have to call this a win for his defense attorney and a loss for the parole officer. And these hearings are just so different than what we're used to. I mean, they're at the level of like a court proceeding. The defense attorney just puts up a fight. I mean, by all accounts, I think that it's nuts, but I have to give her credit. I think she's doing a great job in terms of just like putting up a vicious, ferocious defense. And then the parole officer, I mean, it's like, it's as if the parole officer has to be at the level of of an attorney as well. I mean, he has to create an entire case. He has to know how to structure it, how to word it, how to be quick enough to then to return a counter argument. The whole thing is just so different than what we're used to, and nothing I'd really to expect that would exist. And to imagine being a parole officer out there on the street, doing everything that you have to do normally as a parole officer, and then also have to come out here and basically be an attorney. Now, if you're wondering what he's in for, and thank you, Richard, for providing this information. I mean, he has a long track record, if you can imagine, the dates. But this offense is for a 2012 shooting. He shot a high school kid in the leg. Maybe it was, well, basically, he took a plea deal. So he took a plea deal He was 20 years old at the time he took the plea deal, so he was 19 at the time of the shooting. It was a 10-year sentence, although, like Connecticut likes to do this, it was 5 of it suspended, so he got 5 years for shooting someone. And it does blow my mind. I mean, you can get attempted homicide, but no, he walks away with 5 years that he has to serve. And it's like, as a Bloods gang member, which he's being accused of, like, that's probably, you might say, your rite of passage. It's like, I'll do the 5 years. It's kind of expected. And I think that's just insane. But it's kind of what this light on crime stuff that we see so much of. It does blow my mind, because you can get 5 years for just about anything, you would think. But then he has and 5 years probation, and that's what he's being violated on now. Now the two or special parole, I think, is what he's being. But anyways, so the student who suffered a bullet wound in the leg in the incident last March survived, police said. And then Rowe pled guilty under the Alford doctrine, which means he doesn't agree with some or all of the state's allegations, but conceded he would likely be convicted. An Alford plea. So the defense attorney, Joseph, declined to comment following Friday's hearing. The prosecutor, senior assistant state attorney, and the reason I'm not showing this is because there's like private information, and I don't want to violate any of YouTube stuff, so I'm just reading it to you. The assistant state's attorney said it appeared to be gang related. Oh, who would have thought? Authorities believe it was part of a feud between the groups from east and west side of Stamford. A second man charged in the shooting, Kevin of Orange Street, pled guilty to first-degree assault in November and was sentenced to 12 years for the shooting, as well as an armed bank robbery and convenience store heist. So his co-defendant robs a bank, robs a convenience store, shoots someone, and gets 12 years. I mean, couldn't they just do the federal charge and give, like, maybe they also got him on a federal charge? I don't know. Police believe the gun used in the string of armed holdups at the gas stations, fast food shops, and other businesses throughout the east side last year. Authorities used several witness statements to connect him and his co-defendants to the shooting. The morning after the student was shot, he posted on the victim's Facebook wall, "You're a tough guy, suck it up." Yeah, he's real smart, this guy, with his social media. I mean, he hasn't learned that much, huh? An arrest warrant affidavit states. Talking about that, let's talk about these. I mean, I'm sure many of you are familiar, or probably all of you are familiar with Bloods, right? And I've seen enough of these documentaries where it's scary. This stuff is real. They you have members that take lives without even blinking an eye. They're fine with serving their prison time, and life is not precious at all. It's actually, the senseless crimes that are committed. It's terrifying. I was scared. I'm scared for the parole officer. I'd be terrified. Are there, like, someone would have to tell me, are there like unspoken rules where you don't, for self-preservation, you don't retaliate against a parole officer the same way you're not supposed to against a district attorney, but again, when it's certain, it just makes me wonder. I'd be so afraid. Imagine being a parole officer, putting your life on the line, trying to do your job. And I think it is your life on the line. I mean, I'd be terrified. I would be terrified. And I would say, why am I doing this? I mean, I thought he did a great job. He brings all the evidence. He made a few mistakes that we'll go over. And then all for it to just be for naught, It's like, why would I continue to risk? Why would I risk, like, it's frustrating. It's got to be so frustrating. Let's go check how much he's getting paid to be basically an attorney and a parole officer And it's like, so parole officer in Connecticut, how much does parole officer in Connecticut make? Connecticut is 67,000 as of January 26th. Wow, that's pretty accurate, huh? And but range typically between 61,000 and 76,000. So it seems like he's basically working a thankless, brutal, probably dangerous job. And the median is 70, 68, 69,000, which just in today's day and age, especially Connecticut, it's just that's a tough living. Okay, so I don't know if I was just recording for a few minutes and talking to myself, but either way, here's something I just found because I was curious. You know, parole officers carry weapons, and apparently there's been dangerous instances where police officers have drawn guns on parole officers because they don't, you know, they're not really identifiable. So they had to. This is in 2018. So what did they decide to do? They submitted testimony in support because parole officers need a radio and car outfitted with emergency lights and sirens to do their job safely and effectively. So now they're basically police officers and attorneys. The work of parole officers is dangerous. They regularly respond to emergencies, are on call 24/7. They are provided an unmarked vehicle because they could be called out to respond to an emergency anytime, day or night. With more offenders being released and fewer going back to jail because of second chance society initiative, there seems to be a rise in criminal violations among supervised population. Currently, about a third of parole officers have access to radio. It is difficult for civilians and police officers to identify parole officers in emergency situations because they're unmarked cars without emergency lighting. Parole officers unable to identify an unmarked officer vehicle has driven past emergencies where they could have assisted. In one instance, police officer drew a gun on a parole officer because they did not know who they were. Providing parole officers with radios and vehicles with emergency lights and sirens would improve the outcomes of safety and interact. None expressed. So there's no opposition. So I guess all the parole officers in Connecticut now drive around looking like policemen. Gotta tell you, I don't know why anyone would want to take that job. Okay. I digress. So there are lists. They said 1, AR-15. And so there's an Instagram photo of his buddy with an AR-15, and he's next to him doing the blood sign. And the blood sign, I'll digress again, but I don't know if YouTube's going to allow me to even do this stuff. This is educational only, right? So you know, it's one of these signs, I guess. And they say, and I did it. This is unbelievable to me. In Louisiana, they'd be like, "Okay, you're done, bye." But hearing, it's like, well, according to the statute in Connecticut, the gun, we need to know if it's a real gun or not, and we couldn't tell if it's real. Could have been fake. 2, we need to know that it's operable, and there's no proof that it's operable. And I'm like, what? I mean, by definition, the only way that you're going to get someone on a violation with a picture or even a video of someone holding a weapon is if you see them shoot it. That's crazy. I mean, can you imagine that? That's the laws that are being created to protect gang members. That's crazy to me. I mean, it's like if you're, in Louisiana, it doesn't make a difference what it is. It could be a fake gun, it could be a pellet gun, an airsoft gun. They're like, you cannot be around any weapon. You're on parole. That's your job. Follow the rules. In Connecticut, it's like, nah, just you can even be around a real gun. Just if it's not operable. What? Okay. I wonder who wrote that legislation. You just can't make it up. Then the idea that he went to California, we can't find a finding in that because I don't have now the only thing that he should have done was the truth is he should have sent those reports, but it was insinuated by the defense that anyone could have made up those reports. It could have been the parole officer, and they're insinuating the parole officer is forging stuff, which is just like, and basically the board agreed. And yeah, he should have handed the reports over. If you get reports and it's all in a file and you send it. So it is interesting that he didn't do that. But there's no proof. And he had a point. He's like, well, I mean, what? So all three things. So he went on the JetBlue Wi-Fi. He had the communication about going out west, and he had the photos with the timestamps. But they're like, well, there's no proof. West could have meant anything. It could have meant West Connecticut. And the Wi-Fi, his defense attorney said, well, with the Wi-Fi, there's no proof that it was even him on the phone, even if it was on the JetBlue Wi-Fi. And that's an interesting thing. I saw a funny show once where the guy went into it's called Silicon Valley. Have you ever seen it? So anyways, it was two business partners and they went into a venture capitalist firm for the first time, supposedly, to discuss a deal. But his partner's phone automatically clicked into the venture firm's Wi-Fi and his partner saw it. And he's like, wait, why did it automatically? You've been here before. And then, that was how he was busted for having gone to the firm behind his back. And that's an interesting thing with the Wi-Fi, right? But no, there's no proof it's even his phone. Now, the board did find that there's proof that they believed it was his phone, but it was just funny that the defense was like, what? It's a phone he sometimes uses. Okay. Like, that's not the way phones work anymore. Like, you leave the house without your wallet, it's fine. You leave your house but you leave your house without your phone, you're going back, you're getting your phone. The location data is not proof. Oh, the funny part too was about the photos. She like really went all out. She goes, you claim that he has photos on his Instagram and on his Facebook that first she says black and white, I was like, when she was saying, I was like, how is that? Unless he used a black and white filter, it's not gonna. So who knows how that happened? Someone probably printed it on a black and white paper and put it in her file, and she just assumed it was black and white. But and she goes through it. She's like, well, there are 59 photos on Instagram, but only 3 of them are gang affiliated. That's 5%. There were 5 of 97 photos on Facebook. That's only 5%. There are 20 of 402 photos. That's only 4%. It's like just 5% of the photos. And it's like getting gaslit. It's like when you take a step back, it's like, what's your point? Like, oh yeah, every photo is gonna be gang related. So I like, what's your point? What are you saying? But she had to like do that. She sat there and she counted all the photos and she took a calculator out and she got the exact percentages and made that all part of the defense. And I'm blown away. I don't know what drives these defense attorneys, public defenders. To me, it just seems so obvious that this guy is a gang member. He's as the parole officer said, an OG, which is, according to this, number 2, if I'm understanding this correctly, on top of the food chain. So he's like a senior member, it seems, and on a part of a dangerous gang. And what makes you as a defense attorney want to like just go all gung-ho? I don't really understand. But I guess it's just something that you have to believe. You have to believe that he's innocent, and I mean, to believe he's innocent, you're also believing that the parole officer has like malicious intent, I think. But I like how the parole officer said, that's a lot to unpack. And then when he was cut off, he's like, ma'am, I waited a long time to answer the question. Let me answer the question. But it's interesting, these hearings. So now he's going to have the official revocation hearing. They're only going to be able to bring 2 items of evidence. One is that he isn't a gang member, which they're going to look at as being classified as one. You can see he's in handcuffs at his hearing. And then 2 is that he didn't give the passwords to his phone. And who knows, when the parole board looks at that, they might say, well, the classification could be wrong. Like, why are you classifying this way? And the phone thing, it could be you know, they might just say it's not serious enough to revoke him. So we'll see. Well, I'll let you know. I'll keep you posted. Thank you, Richard, for providing this all together. And I think with that, I'll let you go.